Hi, everyone. Good afternoon. As Benji said, my name is Katherine Brock. I'm an attorney in Smith Anderson's Tech Trans and IP group. Really excited to be here with you today. I want you to consider this as a primer on IP. What is it? Why do we care? How does it impact your business? What are at a very high level, the buckets of IP that U.S. law recognizes? And then we're going to take a deeper dive into trademarks specifically. My personal favorite category of IP. They affect all of us as business owners and consumers. Very wise paralegal in the audience, Kim, once said that trademarks rule the world. So I love talking about them. I'm super excited to do a deeper dive today. And can everyone hear me okay? All right, great. Benji handled this for me, but I won't belabor it. It's not legal advice. We don't have an attorney-client relationship here today. Just happy to give you as much educational information as we can. So what is IP? This is a gross oversimplification and a representative list of types of IP. But generally think of it as creations of the mind. You might think of an invention or, a patent. You might think of a logo, a trademark. But it's essentially an intangible right in this creation of your mind. There are 4 principal categories of IP that U.S. law recognizes, and one of the things I'd like for you to take away today is that they're not mutually exclusive, and this will get into a little bit with respect to your business strategy, what type of IP protection is appropriate for you, and the goals that your business has. For example, something could qualify as a patent and a trade secret, and you might need to figure out, hey, how do I want to explore protecting this, and how do I want this to play into my organizational goals? So at a very high level, patents, think of inventions. They're governed by the U.S. Patent and Trademark Office. This is the one category of IP here where you truly have no rights in your invention unless you register it as a patent. Someone can come along and copy it. Federal registration is highly recommended, and you do need to work with a specific patent attorney if that's something that you are looking at for your business with respect to patent protection. Depending on the type of patent, protection lasts for 15 to 20 years. Again, I could, talk about the nuances there, but that's really about all you need to know today. Trademarks, we're going to talk about in more detail, but think of trademarks as source identifiers. They can be words, logos, symbols, even sounds or fragrances. There's a whole subset of trademark law that I don't get to practice as much on my, in my daily life, because not many people come to me and say, hey, I have a sound mark I'd like to pursue. But think about Netflix. Your roommate, your significant other's in the other room and you hear a but that sound is a registered sound mark that Netflix owns. So trademarks can be a lot of things beyond just words or symbols. So they're just intended to tell you where the product is coming from. Copyright law protects, and I should say trademarks are also governed by the United States Patent and Trademark Office along with patents. Copyright is governed by the U.S. Copyright Office. It refers to, original works of authorship fixed in a tangible medium. So you're thinking of literary works, visual works, at a basic level. It extends to, other things, sculptures, et cetera, but you get the general idea of an artistic expression with copyright. And then trade secrets, they're a bit unique in that, patent, trademark, and copyright, you all have the option to apply for federal registration and get, rights solidified by a governing body. At the federal level. Trade secrets are a little bit different because when you file for protection for the other forms of IP, you are essentially publicly disclosing the IP that you're claiming. If you file for a trademark application, you're disclosing the goods and services claimed in your application and what your mark is and the features of your mark. If you apply for a patent, you're disclosing, hey, this is my technology and I may gain rights in it and be able to exclude you from imitating it for a period of time. But it becomes public information versus a trade secret. So trade secrets are valuable because they're secret. Some examples might be the KFC spices, the McDonald's Big Mac sauce. Like, think about it as the secret sauce that gives you an edge over your competitors, that really makes your product what it is. And it's valuable because no one else knows what it is. No one knows that secret sauce. And as long as you protect it, you take reasonable measures to keep it secret, it will be protected as a trade secret. So why do we care about IP and how does it relate to your business? So it is legal jargon, but aside from that, it's really a business strategy. A good example is, and I alluded to this earlier, but you come up with, say you invent a process for manufacturing, a product, and you think, hey, this is a great process. I want to file a patent on it. Or you could think, well, okay, if I file a patent, I might get rights in it, but it's going to be disclosed to the public, and my right to exclude others from practicing that same invention is going to expire in 15 to 20 years. So do I want this to remain a secret forever? So would I be better off, considering trade secret protection and just, keeping this in-house? So those are considerations that you think about when you think about how you protect your IP. And I'll probably sound like a broken record today, but this is where it comes in handy to speak with a qualified legal professional who can advise you on your specific situation. One thing that's really important, IP can generate additional revenue for your business. If you have rights in IP, you can license it, you can commercialize, monetize it. Investors like to see that you have IP protection. They like knowing that if you've, invested in your brand, you spent a lot of money, you've ramped up R&D, someone's not going to come along, a third party is not going to come along and say, wait, I have rights in that. You're infringing my rights. Please cease and desist. So investors like knowing that you own the rights you purport to own, or that someone is not going to come along and mess with your product and take revenue away from your business. And last but not least, federal registration is really a way of putting the public on notice that you own rights in the invention. You'll see things that say patent pending. You'll see, if you just read bottles, read packages, you'll see patent pending, or you'll see US patent number X, or you'll see the circle R symbol for registered trademark, or you'll see the copyright symbol. So it really puts the public on notice of your rights, and the idea is to deter confusion in the marketplace and prevent litigation. So my favorite part, what's a trademark? It's an IP right that allows the owner to control use of the mark. A trademark, again, can be a number of things, a logo, a symbol. Think of the McDonald's arches. You're driving along the highway, you see those golden arches, you know exactly what that is. You know you're gonna pull off and find a McDonald's. They're super fun. The goal with trademarks is to serve as a source identifier to protect both the consumer and the brand owner. And the reason is, if you're a consumer and there's a product that you like and you know that product is good for you, it's healthy for you, you go online to buy it, or you walk into the store and you see a product with a similar name or a similar packaging design, that gets confusing. And so you want to make sure that, we, as practitioners of the law, want to help protect consumers from buying inferior products that are imitating and building off the goodwill of another brand. So that's how it protects consumers. And then, the rationale is really the same for brand owners. So you don't want a copycat coming in and piggybacking off of the goodwill that you've built with your brand and the quality product that you've put out in the market. So, an overview of the federal registration process. I'm not going to read this word for word. I think if I wanted to give you some takeaways here, the U.S. Patent and Trademark Office is, the governing entity for federal registration. What it gives you is, exclusive nationwide rights to use your mark and enforce those rights against subsequent users of the mark. So, what this means is that if you get if you federally register a trademark, and maybe someone was using it before you, you can't stop them from continuing to use their mark, but you can sort of box them in geographically to the extent of where their common law rights are. If you have a local, say I started Brock's Bakery and I wanted a federal trademark for that name, and I started selling cakes all over the country, but there is a small Brock's Bakery in Maine that only operates in Maine, and they've been using that name long before me. I can't stop them from continuing to do what they do, but moving forward against subsequent users who try to come in and create that name and sell cakes across the U.S. Nope, that's mine. So that's the goal. It protects you against subsequent users, and it gives you the right to enforce. And so trademarks, I would say, they give you both a right and a responsibility. The right to use, the responsibility to use, and the responsibility to enforce. You're permitted to use the circle R, which is cool. Clients get very excited when they can replace the little TM symbol with the R symbol. If you see the TM symbol on products, it means that the owner of that product believes that they have rights in it. They're trying to build rights under common law in that product and establish their brand, but it means that they don't own a federal registration. It could be that they never planned to. It could be that they've applied for rights but don't yet have them. But the TM symbol is a means of also putting the public on notice of, hey, we think we have rights in this name and we're building our rights in that name, even if they don't have a federal registration. So there is a little bit of tension in trademark law between common law rights and federally registered rights. And that's where, depending on your specific situation, the advice of an IP practitioner can be really, really helpful with, helping you navigate that process and what all that means and preventing confusion. Okay, so for risk of sounding like a broken record, determining whether a trademark application is right for you it's a legal decision, it's also a business decision, and it's something that, probably requires input from a lot of parties. Someone in marketing, someone in legal. You want to have an idea of whether this is the right thing for you to pursue. So considerations before applying for a trademark at the federal level, not in any particular order, but you want to know, I've come up with this product. It claims shampoo and other, toiletries. Maybe I sell shampoo and toothpaste and, body wash under the name Brock. So you want to, before applying, have an idea of what your mark is, what you want to register, and then whether or not you might be successful at registering that mark. That's where, an attorney or at least a seasoned business professional who's been around the block a few times and who's, worked with attorneys in the past and kind of know how the USPTO works and know how the, trademark process works. That's where they can be particularly helpful, because there are a number of reasons why a trademark may not be registrable. It could be that there is already someone out there who's acquired rights in the name that you're trying to acquire. And just because someone has rights in a name doesn't mean that you can't also have rights in that name for unrelated products. For example, Dove is a great example. People love, this example, like Dove chocolate and Dove soap. Two unrelated products, but they've registered the same name. So it's possible. That's something that, if you did a search of trademarks, you might say, oh no, Dove's taken, I can't use Dove with my product, but maybe you can. Maybe you're selling garden hoses. I don't think any examining attorney is going to say, does that relate to shampoo? Don't quote me on that. Examiners are getting increasingly conservative and unpredictable, and I will couch that. But yeah, so another reason your trademark might not be registrable, a common thing that we see is examining attorneys refusing trademarks on the basis that something is descriptive or generic of the goods. And so say you wanted to brand your product the green chair, and you applied to register the mark the green chair, and you're selling a green chair. The USPTO is going to potentially laugh in your face and say, that's as generic as it comes. You can't just claim the rights in the name green chair by selling green chairs. So consider a different example that we all might be familiar with in Raleigh, Red Hat Amphitheater. There's a level of arbitrariness, a level of distinctiveness when you apply the name Red Hat to an amphitheater versus the sales of a red hat. So there's just a lot of really cool nuances and considerations when you're looking at picking a name, and I could go on all day. If anyone has questions on that, happy to speak after the session, but yeah, you just kind of want to engage counsel and say, hey, what are the chances that this could work out for me at the federal registration level? One thing that is super important, filing basis. So I think a common misconception is that you can't apply for a trademark unless you're already using it. The key to successful registration is use in commerce, and before you can obtain a registration, you do need to be using your mark. But, as part of your business planning, if you've developed a product and you plan to launch it in the next year to 3 years, you can go ahead and file an application on an intent to use basis, and that will help preserve, early priority rights at the U.S. Patent and Trademark Office. And so what will happen is, we'll get into the prosecution process in a little bit more detail in a couple slides, but essentially, if you pass muster with the government screening attorney, you'll proceed to publication, and you then have about 3 years before you have to put your mark into use. If you don't eventually use it within the required amount of time, you lose it. But they do give you 3 years. Now, nothing comes for free, so the USPTO is going to check in with you you actually have to kind of keep an eye on it yourself. They might send you a courtesy reminder, but they nudge you we'll say every 6 months and say, hey, are you using this yet? If not, give us some money and keep your application alive. So nothing's free, but you do have the option as you're thinking about your business plans, lock down rights early, with an early filing date, preserve priority. And then once you pass through the prosecution process with the government attorney, you can then worry about proving or alleging and proving use in commerce to really lock in that registration. Okay, so how does the process start? Once you've gone through all of those considerations, again, this is not an exhaustive list. The USPTO, as much as I like to say seek advice of counsel, the USPTO has a ton of great resources out there. They offer free webinars, especially for, young business owners, even for, young attorneys, just as refreshers. So you can get a lot of resources through the USPTO website that'll tell you exactly what you need to prepare and file an application. So these are just considerations that you'll want to kind of keep in mind as you're considering the process. Definitely not exhaustive. So I laughed a little bit when I put this slide together. The USPTO is claiming that their current processing times are 6 to 9 months. Those tend to, they push the limits of that. So I'd say they're closer to 9 months on a lot of what we're seeing, sometimes longer. I've seen up to a year even, but they will surprise you. And with the political climate, it's hard to say what's going to happen at the USPTO. Are they going to be cutting resources? Are wait times going to be longer? We don't really know. But once you've submitted an application, you can expect to hear crickets for several months, up to a year on your application. So don't panic. You can monitor the status of your application. There are instructions on the USPTO website as how to do that, but you really do how people tell you have to advocate for yourself in life and your job, at the doctor, as a patient. You kind of have to advocate for yourself as at the USPTO. You have to keep an eye on your application and make sure that it's proceeding through the proper channels. So once they've done an initial examination of your application, you're going to hear from the examining attorney if things went off without a hitch, there are no issues with the application. They'll say, great job, we're going to publish this for opposition. If there are some, issues with your application, maybe it's technical, maybe you mistyped your address and they say, hey, that's not a valid address. Send us your correct address, and then that resolves it. Sometimes they say, hey, everything looks good, just tweak this language a little bit so that it conforms with our preferred language in the trademark ID manual. Other times they might flag it and they say, hey, you've applied for Brock's Bakery, but there is a Clock's Bakery. Could be confusing maybe to consumers. So then they might invite me to distinguish and file arguments and say, hey, no, it's a totally different mark. It's a different word. It's you have to get creative sometimes with the examiners, but basically if they reject your application, you do have the opportunity to respond and try to distinguish your application from any marks that they've identified that could be blocking your registration or any technical issues. So you do have a couple bites at the apple to resolve any issues. Once you've gone back and forth a round or two with the examining attorney, you're either going to receive a final approval or a denial of your application. So once approved, regardless of whether you filed your application on an intent to use basis, remember I said you could file prior to using in commerce, or you could file if you're already using it and you're good to go and you want to submit all the supporting documentation alleging use, proving use essentially. Regardless of which route you've taken with your application, it's going to be published in the Trademark Official Gazette. This gives 30 days for third parties to oppose your registration. I don't see this too often. It happens. It essentially initiates a litigation proceeding with the Trademark Trial and Appeal Board, but usually examining attorneys tend to apply a higher level of scrutiny when they're reviewing trademarks than you would run into in the marketplace. So it does happen, but I wouldn't say that it's super common that the USPTO approves your mark for publication, which is a precursor to registration. And so it's not super common that a third party comes in there and says, wait a minute, I'm going to mess with this. I think that's actually confusing with my brand. But it does happen, and it's something to be aware of. So after 30 days, if no one files an opposition, if you've already used your mark in commerce, you've submitted a supporting specimen, you've alleged to the USPTO, submitted a declaration saying, hey, I've been using this, these are the dates I started using it, this is the specimen, this is a picture of my product, this is a screenshot from my website showing what I do. If you've done all that, you're going to be registered, which is great. If you filed on an intent to use basis and you pass the publication process, you at this point have 3 years to start using your mark. And like I said, nothing's free. So you'll get pinged every 6 months. And if you're not using it, you can pay a fee and keep your application alive. But you need to put that mark into commerce in the next 3 years. And if you don't, your application will go abandoned. And then, someone else could come behind you and pick up those rights. So it is something to just keep in mind. You have some time, but not all the time in the world. So say your trademark registered, now what? First of all, congratulations. It's really exciting. It's really rewarding to be able to tell clients, we got your mark registered. Like, this is great. You can now use the Circle R, throw away that TM. You get the rights you've been looking for. You can enforce them nationwide, like I said, against subsequent users of the mark. But with this accomplishment also comes responsibility. So congratulations, now use it or lose it. Once you have your registration, about 5 years later, the USPTO is going to come knocking and saying, hey, are you still using this? If so, prove it, which means, filing proof that you're still using your mark in commerce, with fees, of course. And then, between the 9th and 10th year, you're also going to, once again, have to show use in commerce that you're still using it. And this feels burdensome, but it's a fair policy. I mean, we don't want trademark trolls. We don't want people securing rights and marks and then just squatting on them and never using them and then stifling competition in the marketplace. So that's why you have to prove continued use. But once you kind of clear that hurdle of 5 years, 10 years, from there, you're good for another 10 years. And you just renew your mark, basically once a decade after that. And the great thing about trademarks is that if you use them in perpetuity, you keep the registration in perpetuity. So it's unlike a patent or a copyright where your protection will expire after a period of time, as long as you're using it. What if your registration's refused? In some cases, you can't get it resolved. I mentioned this before, examiners at the USPTO are becoming increasingly conservative over the last few years. It's something we've definitely noticed, and sometimes you just can't get it across the finish line. You get a final refusal. I don't have this up there. That's not the kiss of death necessarily. You can initiate appeal proceedings if you think you have a strong case for why your mark should be registered. That can be time-consuming and costly, but it is an option. This is where, if you have not engaged an attorney up to this point, highly recommend it. They can give you an idea of next steps and the risks involved with the next steps. It may be that you had an ultra-conservative examining attorney who denied your registration because of an existing trademark, and the brand owner lives in Seattle, and they don't reach many customers outside of the Pacific Northwest, and you have an arguably distinguishable trademark, and you operate out of Florida, and you move through different market channels, and there's not a whole lot of room for overlap, but for some reason the examining attorney disagreed. Consult with an attorney. They may say, you know what, you can proceed to use your mark without a federal registration. These are the risks in doing so. It might be low risk in this scenario, or you might need to be aware there are some higher risks if you do want to keep using this mark that you failed to achieve the registration for. So that's one thing to keep in mind. They may advise you rebrand right now. That's also a possibility. So you have options, and the best thing I can recommend is just understand your risks for moving forward. I really can't harp on anything much more than that. So takeaways, federal registration, again, is not required to use your trademark. You start using your business name in connection with the products you sell, the services you provide. You're automatically building rights, at common law in that mark. You're not required to register, but going through the process to consider federal registration will confer the additional rights for exclusive use nationwide, rights to enforce. Again, it has benefits for showing investors that you have robust assets that include, protected intellectual property. Consider federal protection early before investing significant resources in your brand. And again, whether it's something you know how to do with searching the USPTO database, if you're relatively familiar with the area, whether it's engaging an attorney, start early. It's my least favorite part of my job is when someone comes in and they're married to their brand name and they haven't vetted it, and they put their blood, sweat, and tears into it, and you have to say, this is a risky name for you to use. You can try it. You might get a cease and desist. We have to kind of, just really, really advise start early. Start early, because you don't want to have to start over. And then, again, in the U.S., I should say, as much as we encourage engaging attorneys to help you through this process, as long as you are based in the U.S., you do not have to have an attorney file your trademark application. You can do it yourself as as an individual. Your business can do it. You don't need an attorney to do the process. That's unlike patents, where you do need a specific type of patent attorney to prosecute that application for you. They generally have a hard science background, and there is a reason I'm not a patent attorney. But yeah, we're really here to guide you, to help you understand the risks with pursuing registration, the risks of not pursuing registration, and really just using your mark in the marketplace, and just how it can help your business, how it may hurt your business, depending on what the federal trademark landscape looks like, depending on what the local trademark landscape looks like. So you have a lot of considerations there, but you are not required to engage an attorney. It is highly recommended, though. So if that's one thing I can get you to take away from this, I think that's great. And yes. Sure.
Since the creator of the state trademark registration is here in our audience, and I'd also love a little bit of commentary around names and logos,
sure,
and whether or not a trade name and a trademark, help me understand that, when green chair might not work for a trademark, but a logo of a green chair
sure
could you expand on those two things for me?
Of
Thanks.
course. So state level trademark registration, it's similar to federal in that it gives you rights to enforce your trademark within the state with which you've registered. So if you have I think I've given a couple examples where you have a party A in Maine and party B in Florida, and it's enough for a federal government attorney to say, that's too confusing, but realistically in the marketplace, there's going to not much room for overlap or confusion, from the perspective of a consumer. So you can apply to register your mark through the Secretary of State in your state. And so that will confer more limited rights, but you can still enforce your rights in state court. So that's benefit to state registration. But I will say this, if you do achieve federal registration, you do not also need a state registration. Think of it as, potentially a backup. And then the question of words versus logos. So logos can also be descriptive. If you had a logo of a green chair selling green chairs, that might also draw a similar objection. But I guess one thing I didn't really mention, I mentioned that trademarks could be a combination of things on the list that could be trademarks. So, in some cases, you can combine the image of a green chair with other wording that is distinctive. I'm pulling something out of thin air, so don't go try to register this, but red hat green chair, since I said red hat earlier, you could say red hat green chair, red hat image of a green chair. That would mitigate maybe some concerns that an examining attorney would have with respect to, is this merely a descriptive mark that is just describing the product such that there's really no unique branding? There's really no distinctiveness with this. So when it comes to logos, using them instead of words can be helpful with circumventing some things. Using them with a combination of words, which is what we would call a composite trademark, can help, get around refusals that you might otherwise receive because they do make your marks more distinctive. But you do also have to be careful in that if you exclusively applied for a picture of a green chair selling green chairs, you might draw a similar objection. Does that answer your question?
Yeah, it's just understanding that the logo matters.
Yes, logos do matter. Any other questions before I hand this off to David?
Not a question, but at the Secretary of State's office, you can get your trademark approved in a much shorter period of time. And if you're only dealing in North Carolina and don't have the notion that sometime later you may need a nationwide mark, And if that would be the case, you could get your North Carolina mark pretty quickly, and then simultaneously do the process to get the national mark. A lot of people that we deal with don't have any dreams of selling outside of North Carolina, and but want to protect it. And it's also a little tidbit that it can be an asset on your balance sheet. You can put some value to it when you are thinking about expanding, going for a loan, or having investors, because those are the kind of things they look for.
Thank you.
No, it's cheaper too. Secretary Marshall reminds us.
I have trademark. I own the trademark for my company name and the logos, two different logos. I know that you said that if we already have a federal trademark, we don't need the state trademark, but would it hurt to have the state trademark as well? Or
No, it wouldn't hurt you to have it. And that comes down to, business decision. Do you also want to spend the money to apply? Like she said, it's a faster process, but having the federal registration will give you the right to enforce in North Carolina, as well as the other states. So it's definitely not necessary, but you can.
Okay, one more quick question, then we gotta move on.
So what happens when there's a conflict between a copyright for an image maybe that an artist creates and a trademark that you find out after the fact someone has put similar words together and it's just words versus an image that's a copyright?
Okay, can you repeat that one more time so I make sure I understand?
What happens, well, in general, what happens if there's a conflict between an approved copyright and an approved trademark?
So that depends. I mean, something that might pass muster under trademark law could present a problem. This is all hypothetical, of course. It could infringe someone else's copyright because, trademarks, you can register logos, you search the USPTO database, you do your little design code searching, and you say, hey, there's nothing here. But maybe someone has registered a copyright for a sculpture that has like the same face as the logo you've registered. So, as that's something to be mindful of as a business owner when you're thinking about types of IP, which is why I said the buckets aren't necessarily mutually exclusive. So you'll want to consider which, if any, or which additional avenues of IP protection could be done. And that's something that we see in our analysis day to day is we'll get someone asking for a trademark, and then sometimes we'll say, wait, do we need to be worried about a copyright issue here? So there is a little bit of tension there. So I hope that answers your question. You do have to consider both. Not in every situation, but it does come up. All right. David, you're up. Thank you.
Hey, folks. Like Benji mentioned, my name is David Center. I'm an attorney at Smith Anderson, and I've got 15 minutes to tell you everything you need to know about data privacy and security.
You can have 20.
Okay, 20. Or just scare you to death. We'll see which one we accomplish today. But the reality is, with small businesses, data privacy and security is an often overlooked area of your business, right? I mean, it's costly. It's time-consuming, and a lot of you are probably saying, "Well, I don't have that much data. I use vendors for processing credit cards, things like that. So why would a threat actor care about the data that I have or the confidential information that I hold or process in my business?" But the reality is, over 50% of data breaches are affected from small businesses, but only 23% of small business owners say that they're actually prepared for a cybersecurity incident. And so there's a tension there. It's incredibly important. It's an issue that folks deal with on a daily basis, but we're not necessarily prepared to deal with that. And so the hope is through this presentation that we'll be able to discuss some of these issues, talk about some practical takeaways that you can use, and show you some resources that you can begin to use to start thinking about these issues to mitigate some of that risk. And I've got a few slides here that I'll run through quickly. It's probably no surprise to you all that we're living in an age known as the era of compromise. And I don't mean reaching across the aisle and making a deal. I'm talking about a data breach, a data compromise. The numbers are just staggering, and they continue to increase every single day. I mean, we had a 78% increase in data compromises from 22 to 23. And again, that's probably no surprise for you all. But what's interesting is there was a decrease over that same period of time of the number of affected individuals. So we had a massive increase in data compromises, but a decrease in individuals. And this is important for small businesses because what the trends have shown is that threat actors, instead of, you're thinking, I'm not a multinational corporation, I don't deal across state lines, what's the big deal? But what threat actors are beginning to focus on are targeted cyber attacks related to specific types of information. You'll still see the massive data breaches where they're going after these large multinational corporations. But again, 50% of these things are occurring with small businesses and targeting specific subsets of personal information and data. And it's probably no surprise the common industries that are at the top of these. Healthcare has been on the top of the list since 2011. So if your business touches on healthcare at all, or if you are collecting or processing employee information related to medical information, then you're at the top of a list for threat actors because that data is so valuable. I mean, it's sensitive information and it's valuable on the dark web. And so again, cost of data breaches continuing to increase. The global average cost of one data breach is $4.88 million. That's the global average. In the U.S., that number is $9.3 million. And so you just see some of these staggering numbers. And in terms of industry, healthcare, again, at the top. So I say all these numbers to encourage you. That was a joke. We're not, but the threat is real, right? It's a real issue that businesses of all sizes across all industries have to deal with. And so we want to look at why you should be concerned. And we'll get to some of the state, federal laws, but contractual obligations, that's one thing. Like let's say you have a vendor that processes credit card numbers for your company. You, to some extent, are responsible for that vendor's use of your customer's data. And so you need to have contractual obligations that speak to who's going to process that data, how they're going to process it, how they're going to protect it. And then ultimately, your small business is your reputation, the trust that you have in the community, the trust that you have with your employees. And you see it every day when a data breach is announced. Immediately, reputation and trust decreases. And so incredibly important considerations as to why these issues are important and should be considered by small businesses. Now, going to practical takeaways from or in this area, the FTC, the Federal Trade Commission, an incredible resource for guidance on how businesses can protect themselves. And one of the resources that they've put out is a notebook. The title is A Guide for Business, Protecting Personal Information. And they identify 5 key principles that businesses should at least think about as they're considering this information. And so it's a free resource available online. Just Google FTC Guide for Business. And a lot of this information that we'll talk about here in the next few minutes is going to be in that guide. But their first key principle is take stock. And that essentially means understand what data you have, right? Are you collecting credit card numbers? Are you collecting personal information? Are you collecting a business's confidential information? What data do you have? Where are you keeping it? Do you have it in a cabinet file? Do you have it somewhere in a cloud service? And then where's it coming in? Are you getting it from customers? Are you getting it from vendors? Are you getting it from your website? Are you collecting data through your website, which is a huge area of focus, not only with regulators, but also with plaintiffs' counsel. And you'll see class action lawsuits related to website data usage. So first, where are you getting your data? And some of the FTC puts out some FAQs that that are really helpful in just, again, considering these issues that should inform your own risk assessment, which is basically identifying what laws apply to your business and then saying, hey, am I meeting that? Or are there any gaps there that I need to work on? And one of those questions that they ask is, what laws require my company to keep data private and secure? And here's just a smattering of different laws that could apply to your particular business. So on the state level, so North Carolina at this time does not have a state comprehensive privacy law, but that's changing every single day. Right now in the United States, there are 19 state comprehensive privacy laws that are either already in effect or will be in effect in the next year. And North Carolina has presented two bills, one in the House and one in the Senate this year, proposing a state comprehensive privacy law that would absolutely affect your businesses. And so staying on top of those legal developments on what's going on in the different state legislatures in the states where you're doing business or where you have customers. And while we don't have a state comprehensive privacy law, what we do have in North Carolina, along with every single other state in the United States, is a data breach notification law. And so whenever you have sensitive, we'll say broadly, financial data of a consumer, of a customer, think Social Security number. If you have an employee Social Security number, if you have a customer Social Security number for some reason, and that number, that information is compromised, then you're required under North Carolina law to notify that individual and then report that to the State Attorney General's office. And so there are very specific guidelines on what you're supposed to do at the state level when you do experience a compromise. Federal law, federal privacy and security law. Again, there's no federal comprehensive privacy law, but what we do have in the United States are sector-specific laws. So you think healthcare, we've got HIPAA, right? You think financial services, we have GLBA, we've got ADA, we've got any acronym you can think of, they're going to have some type of federal law that's going to apply to your particular industry. And so again, it goes back to what industry you're operating in, what type of data are you collecting, and then determining, okay, what law applies to that, and how am I going to reach compliance with that law? The second key principle is scale down. So the idea here is only collect the data that you need for a business purpose. If you don't need it, don't ask for it. If you don't need a customer's address, don't ask them for it. Or if you don't need their Social Security number, don't ask them for it. Don't collect it. And we'll get into, if you do collect it, we'll get into some principles in just a couple minutes on what to do with it then. But operate your business under the theory of the principle of least privilege, which means once you have data that, again, you've collected only because you need it, and then once you have it, make sure that people within your business, that only those people who need it to perform their jobs actually have access to it. You can get into a lot of issues. There was a healthcare provider that had an issue. Healthcare providers have an electronic medical record, right, where they keep all the sensitive health information of their patients. Well, for some reason, this particular provider gave access to that electronic medical record to security guards. And you may be wondering, well, why does the security guard need access to the full electronic medical record? Well, the federal government wondered that same thing. And they said, hey, you don't need to give your security guards access to private, sensitive medical information. And what they found after an investigation was the security guards had accessed over 500 patients' information for no business reason, resulted in a fine with the company and then a 2-year corrective action plan. And so, again, that entity wasn't operating under the principle of least privilege. They were giving access to anybody who had a username and password and thinking that it was okay. But you've got to say, okay, does this individual in my company need access to this information to perform their job? And if they don't give them access. The third one is lock it. And these are the FTC's words. It's cute. But what this boils down to is there are 3 principles under the lock it section, which is you need to have appropriate controls in place with your business. And these are physical controls, administrative controls, and technical controls. Physical controls are what they sound like. It's making sure doors are locked, making sure people have appropriate access, making sure that your data is protected from a physical intrusion, someone walking into your office and grabbing something off of your desk. That's what they mean by physical control. Administrative control relates to policies, procedures, trainings. Are you doing background checks on your employees? Are you creating a culture of compliance? Are you creating a culture of privacy and security compliance? Because remember, you can, and even if you have policies and procedures in place and you go online and you print out this great employee manual, it's only as effective as either you or your employees understand it. Because it's often said that the employees or the business owners are the threat vector for data privacy and security incidents. You know, we're the ones who are opening the phishing email. We're the ones who are talking with IT on the phone, giving them our MFA credentials and allowing access into our systems. And so again, we've got to have these things in place, but we've also got to make sure that our workforce members understand it. And then the last one under Lockett is the technical controls. And here's where you can really you can leverage your IT partners. So if you have a managed service provider who's doing your IT work, or if you have somebody in-house, you really want to understand with that person what technical controls you have into place. Are your systems encrypted? Do you have strong passwords? Are you restricting downloads to only legitimate downloads, things like that. And for non-technical folks in the room like me, that's where a trusted IT advisor, managed service provider, somebody like that can really go a long ways in helping you secure the data that you do have. So the fourth key principle, and I'm flying through these. We may have a few minutes at the end for questions, but the fourth one is pitch it. So get rid of it. So the theme here is properly destroy what you no longer need. And they've got an asterisk beside no longer because remember, you're only collecting what you need. So hopefully you don't have anything that you don't need. And then once you're done with it, get rid of it. Because what that does is, assuming that you've retained things for the appropriate amount of time for all legal consequences or legal obligations that you have, but once you're done with it and that retention period has passed, then delete it or remove it. Because if you do experience a data breach, then that necessarily, if you've deleted or removed non-relevant information, then that limits your exposure in a data breach. Whereas if you keep everything for the last 20 years, including customers' financial information, even though this customer hasn't worked with you in 20 years, then that threat actor, if they get into your systems or your data becomes compromised, they're going to have access to that 20-year-old financial information. And that just increases your liability. And a lot of clients will say, well, we throw away everything. And you've got to dig into it a little bit more. And this FTC question speaks to that. So my company throws away customer financial information once it's no longer needed. On the surface, that sounds great, right? They're getting rid of it. But a proper document retention program is not simply putting it in the trash can, but it's shredding it. It's literally burning it. That's a proper way to dispose of or destroy confidential information because it's still readable, it's still available, even if it's in the trash can. And so the key consideration here is, are you destroying it so that information is no longer usable? And then the last one, plan ahead. This one's probably the most important of all of them because it gets you thinking about what do I need to do in order to protect my business. I need to create a plan for when this happens because it's no longer about is there going to be an intrusion, but what am I going to do in response to it? Because again, every day, you saw the numbers at the beginning, every day we're hearing about new data breaches. And so what plan do you have in place in order to deal with these things before they occur? Because it's much easier to have that conversation and to sit around a table and say, okay, what are we going to do? It's much easier to have that conversation when you're not facing a ransomware incident or when your data hasn't been compromised. There are cooler heads in the air, and you can be a lot more productive in those situations. And And the question here, I own a small company, which is, like a lot of you in this room, aren't these things cost prohibitive? And that absolutely is a concern, right? But there are simple, practical steps that I've flown through in this presentation, but that are also set out in the FTC's guidelines that you can take that don't cost anything. But it's thinking about these issues, it's identifying what data you have, what laws apply to it, and then do I have any gaps in between what my requirements are within the law. So there's your 16-minute primer on data privacy and security, but happy to answer any questions if you all have them.
I'm going to ask a basic one-on-one
Benji.
question for you, David. When you're talking about data,
Yeah.
the data that we are worried about, can you just rattle off like clearly understood social security number is sensitive, but can you rattle off like what all we're talking about so that we kind of get a sense, and then maybe discuss de-identification of data and whether or not that helps with anything?
Yeah, absolutely. So when I'm saying data, I'm saying personal information, which is individually identifiable information, anything connected with your name. And so take California, for example. If you've got California customers and you're collecting their data, you're collecting their information, that's as simple as their name, right? And if you otherwise meet the jurisdictional thresholds for California's privacy law, then that lumps you into having to comply with the CCPA. And so it's name, date of birth, address, health information, obviously that's a sensitive one, financial information, anything that's connected to a specific individual. When it comes to websites, if you're using Google Analytics, you're potentially collecting IP addresses and then browsing activity and then transmitting that information to Google. And Google's saying, great, we love all that data. We want that information. Whereas unbeknownst to you, you may be transferring personal information to Google or to Meta, to Facebook, without the proper controls in place. So it's incredibly broad in terms of individually identifiable information. Yes?
So you're talking about
Sorry, 1 second. Microphone. We'll get it.
So the information that you provided here is more about business to consumer, not business to business.
Correct, yeah. This is business to consumer, but a common question we get is, oh, well, we don't need to be concerned because we just deal with businesses. But you've got employees. The business that you're dealing with has confidential information that you are potentially processing, or at least they're entrusting to you. And so that's when the contractual obligations come into play, because you better believe that if there's a breach at your business and you have to notify that other business, even if it's not consumer information, but it's their confidential information, then they're going to say, hey, this was our confidential information and we need to have assurances that you're properly protecting it. So the same principles apply, but you're right. When we're talking about CCPA, when we're talking about state privacy laws, that's primarily related to consumer information. Any other questions? Okay. Well, thank you, guys.
Beautiful. Well, thank you. We got one more session coming up, so take a quick break. We're going to start it at 3 o'clock. I have no idea what time it is now, but I'm sure we'll give you a couple minutes to get refreshed a little bit, and we'll see you here back in a few minutes. Thank you.